Lalit is practicing CA and he's been helping uh, hundreds of startups based out of India and US in their fundraising, their compliances, and all the accountancy related activities. And the startups are based out of not just in India but in US, UAE, and multiple other countries where Lalit has expanded its reach. Now, so the topic for today's conversation is pretty interesting. So we were just having a quick WhatsApp chat, and there was some new uh, regulation which came in with regards to how can an Indian investor invest in a foreign startup. And from that chat, I could quickly say that this is a very technical topic, and very few people in the country uh, would typically know how to actually invest in a foreign startups, that too at an early stage or at a seed level or a pre-seed level. So I just asked Lily that why don't we get on a live chat and talk about this so that more people would understand without going into typical vocabulary of the investment world altogether, because वो तो किसी के पल्ले पड़ती नहीं है इतनी आसानी से. So we said, why don't we just come together and have a quick chat about it so that everybody knows what exactly we have to do as an Indian investor. So over to you, Lalit. How can an Indian investor invest in a foreign startup at an early stage?
Yeah, so thanks, Brian. Thanks for having me here. And yeah, interesting times. It's a new regulation that's kicked in. Some things have simplified, some things that were allowed in the earlier regime are not going to be allowed. So there are two parts. One, the valid question of how an Indian investor can invest in startup companies. It's a very easy process. Even in the earlier regulation, what it allowed is that you could do LRS remittance, which is Indian resident individuals could invest in foreign companies through the LRS limits that they had. LRS is liberalized remittance scheme, which is having an
Okay.
annual threshold of $250,000. So within that limit, you could invest in the foreign company, and obviously you have to comply with certain other parameters in terms of the type of business that the foreign company is into. What changes in the new regulation? The limit still remains the same of the overall ticket size of 250,000 from the resident individual side. What changes is that there is a new concept that they brought in, which is known as an OPI, which is basically overseas portfolio investment, which wasn't there in the earlier regime. And anything less than 10% of investment in the overseas company will be considered as an OPI, which is a very simple transaction. You have to fill up a few documentation, give it to the bank, and the LRS limits will apply for resident individuals to purchase shares of the foreign company. Now, most of these foreign companies, whenever they issue at the early stage, it's generally a safe. So that's a watch out, the post that I put it on LinkedIn, and that's where the conversation picked up from there. So generally, the instrument that is issued by the foreign companies is in form of safe, which is a simple agreement for future equity, is primarily a convertible instrument, which actually allows the investor to put in money at a valuation cap, which basically converts into preferred stock in the price round. So it's not actually shares in the foreign company, but it's an investment which will actually convert into shares in the subsequent round. Now, what happens is that whether safe investment is allowed or not allowed was always a controversy, even in the old regulation. Basically, the type of instruments that you can invest, RBI had certain guidelines in terms of what are those classifications, and certain banks were allowing safe investments. Like we know a lot of private banks that were allowing that, but there were quite a few public sector banks and also few foreign banks which were not allowing Indian resident individuals to invest in a safe instrument in an overseas company. Now, what changes? We put a question to even our banker, the AD banker we deal with, and they had a meeting with RBI also. So they basically clarified that even in the new regulation, though they have widened the definition of what are the instruments that a resident individual can invest, they have put certain kind of limitation in terms of what a safe really means. So basically, they're also saying that safe is not a valid instrument. Though it has a convertible, though what the regulation allows is that you can invest into equity instruments, quasi-equity instrument, convertible, which are irredeemable instruments, which will automatically get converted into equity or preferred stock or whatever classification of shares it will have. Now, when we look at the safe is having certain provisions of certain termination clauses, and it also has an option of conversion. So it's an optionality, and there is a redeemable clause out there, which makes it redundant as far as an equity instrument is concerned. So basically, the equity capital definition that RBI has defined, it doesn't fit into that. So all the Indian resident individuals who want to invest in a foreign company, maybe they'll have to seek advice in terms of how the safe has to be modified to suit the Indian regulatory requirement, because obviously otherwise plain vanilla safe will not help them. And safe, what generally most of the companies do is basically they pick up the standard YC safe, which is the Y Combinator safe, which is available in the public domain. That's a very common practice that happens. So maybe a slight modification in that document would be required. Now, whether that modification would again be acceptable or not by the bankers, it's only for the time to tell. But I think that's the best approach. And maybe the founders will also have to be wary where they raise investments from Indian individuals, because there are a lot of founders who are kind of based in India, but they incorporate a overseas company and have a downstream back in India. So that again, there's a round tripping issue, which is a separate conversation in terms of how that is supposed to take place. But assuming that they had created the structure in a valid format and they were raising through SAFE, they will also have to be mindful that Indian investors may not be able to put with the current YC SAFE. They may have to do some modification to give it the kind of the transparency and also the color of the equity capital, which is defined in the RBI and ODI new regulations that have just come out on 22nd of August 2022. So two things from the investor perspective also, they have to be mindful, and founders will have to take care. Otherwise, they will not be able to raise funds from Indian investors to invest in a foreign entity. There are other formats, like if the investors and the banks don't agree to the convertible option of a safe, and it's something that is a bottleneck. Now, this option has been there quite a while. In fact, we were using it even in the old regime, which is actually known as a put call option. Now, this is a different kind of a construct, where what happens is that the Indian investor will invest into the Indian subsidiary and have a put call option at the parent level, which is the US company or the Singapore company. Now, for this, you will have to have a structural linkage in place, assuming this is valid as per the current regulations. So you can invest in an Indian subsidiary of the foreign entity and have a put call. What the put call will really do is that there will be a reference share that will be created at the US level. And whenever there is a exit event taking place or a liquidation event, the Indian investors will be able to participate. So they will be exercising the option of the put, and the US company will ensure that there is an exit that is given basis the pro rata distribution that needs to go to the shareholder. Or you can also avail for a swap whenever there is a swap happening, where you can obviously through RBI regulations, you will be able to get shares of a foreign company at a later date whenever the put is exercised. So there's another alternative, but the first option, the preferred route would be that if you can look at the SAFE document, make necessary modifications, and then go ahead with the overseas investors. Now, whatever I've spoken is in relation to assuming the investment by the individual investor in India is less than 10%. If the investment is leading to a shareholding in the foreign entity of more than 10%, which generally happens for a founder situation, then in that case, the regulations are different. The ODI regulations will come into play. It will not be an OPI. It will be more detailed documentation and submission, and then the formation will take place. So this is as far as the investors are concerned. I think I will also come to
good points.
Yeah, so two classifications. One, either look at modification of the SAFE, and we're just talking startups which are unlisted entities. I'm not talking about listed entities because that's a different regulation. And again, within the same regulation, they can even buy shares of foreign entities which are listed in the listed space. But we're just restricting a conversation only to startups which are in the unlisted space and the early investment, which is in the form of SAFE. Had it been a price round, which is preferred stock or a common stock that they're issuing, mostly a preferred stock that gets issued, that's not a problem. That you can always invest through the OPI and also through the LRS overall limits that you have. That's something that is validly allowed. Now, that's only for the investor. Now, I think the other part of the conversation, very important, is that is how do Indian founders create such structures? I think that's a very valid thing, and that's where a big change happens in this regulation. That's our biggest new change that has come along this regulation. But before I go there, maybe if you have further questions on Indian investors, then I can go to the founders having such structures.
Correct. So one, interesting point you touched upon, that the SAFE has certain components which needs to be looked at from a narrower perspective, saying that what it actually means. And of course, an expert can only help in that. But now, so for last 10 years, SAFE has been used as go-to document or go-to investment mechanism for Indian investors as well as outsiders, because you just need to have 2 to 4 pages of document without much of exit clauses and everything, because you are buying basically a future equity, right? So this current regulation eases the investment outside, or it's going to put another layer of extra work in terms of compliances? What do you feel? Is it just a small change which one has to be mindful of while investing? Because put and call option is gonna be
It's
a
it's,
secret
it's
part.
yeah, yeah,
It's
yeah.
not
It's
that
not going to be
easy.
easy. It's not going to be easy
Yeah,
for the
that's
founders
not
and
easy for sure, right? So how easy things have become in terms of the recent regulation which came on 22nd of August 2022.
yeah. So good part is that at least there is a clarification. Last time there was an
Mm-hmm.
ambiguity in terms of what really safe is. Even today, what it actually does is that it broadens the definition of what a equity capital means. Like it wasn't really defined; it just said equity, and then there was some
Okay,
broad definitions. Now it clearly calls out what it qualifies for in terms of principles. So at least the principles are laid down that it has to be pure equity or a compulsorily convertible instrument and
right,
irredeemable nature. So if
right.
these classifications and categorization, if a modification has to be made in SAFE, which I think it's practically possible, it's not nothing that it cannot be done.
Mm-hmm.
But obviously some explanations has to be given. But my strong feeling is that if certain modifications can be done in the SAFE instrument, it can remain a valid instrument that a resident individual can invest. So I think
Okay,
subject to
okay,
modification being accepted, it's a permissible transaction.
got it. And would it be okay to say that now the safe has got or the safe as per current regulation is basically a modified version of convertible note because it has
I
got those terms and condition as well and
Kind
termination
of,
clauses
but
too.
even in the convertible note, like if the convertible note has a termination clause or an optionality clause, even that will not be considered as a valid instrument. So
In
even
India.
for convertible notes, the watch out is that you really have to make it irredeemable and compulsorily convertible. So these are few things that somebody will have to bear in mind.
Interesting. Good share, Lalit. So we talked about SAFE, the new regulation in the SAFE, which came in 22nd of August, and how put and call options are working in terms of investing money outside India. And of course, how irredeemable if you make the convertible note, it becomes a valid instrument again for the investment for Indian investors. Uh, Anything else you would want to touch upon, which basically saves hassle to the Indian investor who's investing at a seed level, pre-seed level, to an unlisted company? Any do's and don'ts you just want to touch upon, which everybody should understand?
Yeah, yeah. So basically, again, first, obviously, the classification of the instrument itself. Then the second thing, very important, is that while you're filing your tax returns, if you've invested in a foreign company, it's important that you make the necessary disclosures in your tax returns. As that's one thing that foreign assets have been not disclosed appropriately can lead you into trouble. So I think it's important that appropriate disclosures are made in the tax returns annually so that you're able to kind of classify your position. And in case if you're holding more than 10%, so it's very important if you're a large investor and if you're going to hold more than 10%, then there are additional filings where you'll have to also comply with the ODI regulation. You'll have to fill in a separate form. And annually, there will be some kind of other documentation submission that you have to do. If it's a simple less than 10%, which is an OPI, and you don't have
Mm-hmm.
management stakes in a foreign
Yeah.
company, it's a very simple transaction. You have to just do it once and then maybe annually just bother about your tax returns. But if it is beyond 10%, then there are more RBI compliances that will come into play in addition to what is there. And obviously, it goes on the largest investor and the first one who does that. So that person will comply, but you also have to ensure that your information is correctly captured. Otherwise, what happens is that when you're exiting, if your appropriate documentation is not in place, then getting the money back in India could be an issue. So you have to make it a point that how you made your investment, whether it was under the LRS or the OPI or the ODI regulation, having those documents in place, because when you're getting your exit realizations, all the bankers will ask you is in terms of how did you acquire the shares of the foreign entity. So that's
Right.
very important to bear in mind. A few cases we've also seen that because there is an annual threshold of $250,000 per year, some may even exceed that. Then in that situation, you have to obviously you don't have an alternative to invest in a foreign company, because if you've exhausted your overall threshold, you're just talking individual investors.
Mm-hmm.
Then in that case, there are other alternatives that you may have to explore. A few individuals, I've seen few banks also. In fact, let's just like Kotak, what they do is that they allow you to open a bank in outside India jurisdiction, maybe Singapore or Dubai, and you can hold money there with the permission route, and you can invest from that overseas fund that you've held outside India. So that's another way. Like if you're not exhausting your limits in this year, maybe you can transfer some money upfront and keep it parked there, and then you can reinvest wherever you want from that investment again. But if you're using that route, whenever there's an exit taking place, remember that you have to bring the money back to India within 30 days. You can't keep it beyond 30 days in that account after the exits have taken place.
Interesting. So there are lot many timelines which have to be taken care when you're basically going out of the country, and it applies when you're putting money outside as well as when you're bringing the money back to the country. Of course, it has to be informed to the RBI, and appropriate tax has to be paid to whatever earnings you make. Thank you so much, Lalit, for sharing your two pieces of information. It has been a very candid discussion, and more such topics we'll touch upon in the coming week, coming month, and multiple such small bites we plan to do, so that we can educate our audiences together, be it from the startup founders perspective, be it from the angel investors perspective, because right now everybody is looking at the startup space and India is growing, and people want to put money in India, people want to put money outside India, to the Indian investors, to the Indian founders who are running their companies outside India. I think this can be a good platform where we can come together and share much more knowledge about these
maybe next time we
investments.
could cover the other topic, like I said, founders creating overseas entity of round tripping.
Absolutely.
It's a long discussion. So
Correct.
it's a watch out for the founders in terms of how the round tripping has to be taken care of in the new regime. So it simplifies certain things, but obviously the earlier round that was simply available is not available today. So some kind of relook has to be done. So maybe separate conversation we can have on that separately.
Absolutely. And to all our viewers, if you are watching this, if you're enjoying the conversation, if you have any doubts regarding how to invest in outside Indian entities, do drop in your comments and we'll be happy to take those questions. Lalit would be happy to answer those questions. Or if there is any other topic which is not clear to anyone, you can just drop in the comments and we will pick it up in the next edition, and we'll be back with our answers. Thank you so much, Lalit, again.
Thank you, Prem. Thanks for having me here.
Thank you.